His eyes find yours the moment you sit down. Not when the bailiff calls the room to order. Not when the gallery rises and settles. Not when the court reporter adjusts her machine and the stenotype keys rest under her fingers like something waiting to detonate. The moment your chair meets the bench, his eyes are already there, already locked, and you understand in the space between one heartbeat and the next that he has been watching the door since they brought him in, that he has been waiting for this exact second. That whatever composure he assembled this morning, whatever agreement he made with himself on the bus from the detention facility, it broke the moment he saw your face appear above the bench. You are 61 years old. You have been a federal judge for 19 years. You have sentenced men to die in prison. You have sentenced men who wept, men who threatened, men who stared at the ceiling and refused to acknowledge the room. You have read the pre-sentence investigation reports on human beings whose lives were disasters from the first page, and you have applied the law to those disasters with the steadiness that the law requires of you, and you have driven home afterward, and eaten dinner, and slept. You know what this room does to people. You know the way the elevated bench changes the architecture of a person, how the extra 18 inches of height rearranges something in the air between you and everyone below. You have sat up here for 19 years and understood that the height is not about power. It is about the clarity that distance allows. It is about the obligation to see. You have never needed distance from anyone in this room the way you need it right now. The robe is heavier than usual. You know this is not possible. It is the same robe, wool blend black, that you have worn for 19 years, but your shoulders register it as weight regardless. The court reporter's keys are still. The assistant U.S. attorney sits at the government's table with a legal pad and a posture that communicates nothing, which is professional and correct. Defense counsel is beside your son. Your son is in a gray suit that someone bought for him, or brought for him, or that he has owned for years and you no longer know which because you no longer know the details of his life with any confidence. And that absence of knowledge is itself a verdict on something, though not the one you're here to deliver. You requested recusal. You submitted the paperwork through proper channels within 72 hours of the case assignment. The motion was reviewed, and the response came back in writing, routed through the chief judge's office. The defendant, your son, had been advised of his right to have the case reassigned. He had consulted with defense counsel. He had waived that right explicitly, in writing, on the record. He wanted you. The ABA Model Code of Judicial Conduct, Canon 2, Rule 2.11 permits this. The law permits this. Your son, who is 29 years old and facing a mandatory minimum of 10 years under federal statute for conspiracy to distribute a controlled substance, methamphetamine, 11 kilograms, a network spanning 3 states, had looked at the roster of available judges and chosen you. You have spent 3 months trying to understand why. The pre-sentence investigation report is in front of you. 64 pages. Probation prepared it over 8 weeks. You have read it 11 times. You know the guidelines calculation. Base offense level 34. Criminal history category 2. 1 prior conviction for simple possession that you did not know about until you read page 7 of this report. Adjusted offense level 32 after acceptance of responsibility. Guidelines range 135 to 168 months. The government is not moving for departure. Defense counsel has filed a motion for a downward variance under 18 U.S.C. Section 3553A, citing the history and characteristics of the defendant, the mitigating circumstances, the nature of his role in the conspiracy. You have read that motion 14 times. You know every argument it contains. You know the ones that hold and the ones that don't. You know this because you are a federal judge who has applied these standards for 19 years. You also know this because the history and characteristics of the defendant include a childhood in your house. The AUSA rises to summarize the government's position. You hear the words, you register them, the network, the quantity, the 3-state reach, the defendant's supervisory role. You have read the wiretap transcripts in the PSR. You have read your son's voice rendered into typed words on a government document, the instructions he gave, the amounts he discussed, the language he used that you do not recognize as the language of anyone you raised. This is the detail that has stayed with you for 3 months, the thing you keep returning to in the dark at 4 in the morning. Not the crime itself, not the law you are required to apply, but the voice in those transcripts. It does not sound like him, which means either those transcripts contain someone you never met, or you never knew him as well as you believed, and you do not know which possibility is worse. Defense counsel rises. The motion for variance is argued carefully, professionally, mitigating factors. The defendants expressed remorse. His cooperation with the government, partial, not substantial, not enough to trigger a 5K 1.1 departure, but documented. His background, his potential for rehabilitation. Counsel is good. You know this because you have watched good counsel for 19 years, and you recognize the difference between performance and belief. And counsel believes this argument. This does not change the guidelines. It does not change the mandatory minimum. It does not change the range of choices available to you, which is narrower than anyone outside this room understands. Because the law is the law, and you took an oath to it long before you took any other oath, and the oath has never asked anything of you that cost you anything like this. Then it is time for allocution. This is the part that is required. Under Rule 32 of the Federal Rules of Criminal Procedure, before imposing sentence, the court must address the defendant personally and ask whether the defendant wishes to make a statement. This is the defendant's right. It exists because the law understands that before a sentence is spoken, the human being about to receive it should have the chance to speak. You have heard hundreds of allocutions. You have heard men read prepared statements with shaking hands. You have heard men say nothing. You have heard men say things that changed the sentence you gave them, not because emotion is a sentencing factor, but because a person's understanding of what they did, the depth of it, the reality of it, is part of the Section 3553A analysis, and you are required to consider it. You look at your son. You ask if he wishes to make a statement. He stands. He is 29 years old, and he is wearing a gray suit, and his hands are at his sides, and he is looking directly at you. And this is the moment you realize something that rearranges every calculation you have been performing for 3 months. He is not here to ask you for mercy. He is not here because he thought you would go easy on him. He is not here because he wanted a lighter sentence from a judge who loved him. You can see it now. You can see it in the way he is standing, in the steadiness of him, in the thing behind his eyes that is not a plea, and it arrives in your body before it arrives in your mind. The understanding of why he waived recusal and chose you, and made it so that the person who raised him would be the one to do this. He wanted you to have to look at him. He wanted the person who was gone for the depositions, and the late nights, and the appellate arguments, and the 100 evenings when the law took precedence over the dinner table. He wanted that person to be the one to sit at that bench and hold the full weight of what he became, not as punishment, not out of cruelty. He is looking at you the way people look at someone they have needed to be truly seen by for a very long time. And the statement he makes is not long, and it does not ask for anything. And when it is over, he sits down, and his hands are folded, and he is still looking at you, and the room is very quiet. You have 19 years of practice at composure. You have it now. Your voice will not waver. Your hands are still on the surface of the bench. The court reporter is ready. The room is waiting. You open the PSR to the sentencing worksheet. You know the guidelines range. You know the mandatory minimum. 10 years. No discretion below it. The statute is absolute. You know the variance motion and the factors and the weight of each one. You know that the law does not have a category for this, for the specific texture of this moment, for the geometry of this room and what it contains. You know that the sentence you are about to pronounce will be reviewed, that it will be on record, that it will be exactly what the law requires of you, because you have spent 19 years making the law's requirements your own, and you are not going to stop now. And your son, who is sitting 12 feet below you in a gray suit, knows this too. That is why he is here. That is why he chose you. He knows what you will do. He has always known what you will do. He has known it since he was a child watching you leave. You address him directly. The law requires this. You meet his eyes, which are your eyes, and you state your findings on the record. The Section 3553A factors: the nature and circumstances of the offense, the history and characteristics of the defendant,
The need for the sentence imposed to reflect the seriousness of the offense, to promote respect for the law, to provide just punishment, to afford adequate deterrence. You address the variance motion. You find that the mitigating factors identified by defense counsel are genuine and documented, and insufficient to overcome the guidelines range. You find that a sentence at the low end of the applicable range, 135 months, is sufficient, but not greater than necessary to comply with the purposes of sentencing. You say 135 months. You say it once, clearly, into the record. The court reporter's keys move. The bailiff shifts. Defense counsel writes something on a legal pad. Your son does not look away. You inform him of his right to appeal. You inform him of the conditions of supervised release he will face upon completion of his sentence. You ask if there are any objections to the sentence as stated. There are none. You note the objection for the record from defense counsel as to the variance denial, preserving the appellate issue, which is correct and proper and will go nowhere because you applied the law correctly and everyone in this room knows it. Then it is done. You say court is adjourned. You stand. The bailiff calls the room to its feet. The gallery rises. Your son rises. And in the half second before you turn toward the door behind the bench, the door that leads back to your chambers, to the desk with the photographs on it, to the office where you have worked for 19 years, you look at him one more time. He is still looking at you, not with anger, not with grief, with something that you will spend the rest of your life learning to name, something that might be the closest thing to honesty that has ever existed between you. Here, in this room, in this configuration, with the full weight of everything you chose laid out in the open at last, measured and recorded and signed. You turn. You walk through the door. It closes behind you. The robe has never felt like anything at all, and today, it weighs everything you never went home for.